Hello, I'm Patrick Farnsworth. Welcome to Access and Privacy Online Commentary. Listeners will know the federal government has been very active on the privacy front since the election. There are a couple of commentaries on these developments, and we will link in our show notes to a commentary with Professor Michael Geist and the Law Bites podcast on Bill C-4 that impacts the personal information of Canadians under the control of federal political parties. In this podcast, we will look at Bill C-2. Canada's federal C-2, the Strong Borders Act, is a sweeping and controversial bill that is currently moving through Parliament. The bill includes lawful access provisions unrelated to borders that expand state powers to access personal information held by electronic service providers. This is not the first time that lawful access powers have been proposed, and privacy advocates across Canada have raised serious concerns about the implications of these measures. In today's commentary, we have FIPA President Mike Larsen and guest Robert Diab, Professor of Law at Thompson Rivers University, for a discussion of C-2 and lawful access. Yeah, I think we wanted to start here by talking about this piece that you had published earlier this month on June 5th for the conversation, titled "The Proposed Strong Borders Act," which is Bill C-2, gives police new invasive search powers that may breach charter rights. So if someone were just to take 10 minutes to understand what was going on, or 5 minutes to understand just some of the basic concerns that you have with your expertise on this subject, what would you say to them?
So the bill is mainly about giving border officials, customs officials, immigration officials more power to enforce the border. But buried within the bill are very substantial new search powers for police and CSIS agents. So some of them have to do with watering down the standards in law for obtaining information, like the subscriber information, the name and address that attaches to an internet account, or for obtaining information about a user account without a warrant. So those are concerning. But also contained in Bill C-2 is an entirely new statute, and I think it's called the Supporting Authorized Access to Information Act, and this is a bill that is modeled after an Australian bill passed in 2018, which in turn is modeled on a British bill passed in 2016 that gives a minister of the government, in our case, it's going to be the Minister of Public Safety, a whole set of powers to compel anyone who provides an electronic service. It's very broadly defined. We can get into it. The power to compel them to, and the word used is install devices, make functional changes to the equipment at the service, the server, the ISP, at Shaw, Rogers, et cetera, or it could be, Gmail, et cetera, to install equipment that allows authorized persons direct access to our data, to private data. Now, there are some safeguards to this, and maybe we can get into, the ones that we've adopted from the Australian legislation. But unlike the Australian legislation, there are a number of safeguards or oversight mechanisms that are missing in our act, and there's an enormous amount of confidentiality. There's power. The powers given to the minister are going to be accompanied by sweeping confidentiality orders. So much of the way this bill will be used will be shrouded in darkness. Maybe Microsoft or Gmail or Rogers will challenge a given order in court, but the kind of broader use that the minister is making and police are making, et cetera, is not at the moment going to be subject to much oversight. Mm-hmm. So those are the main concerns.
I'll jump in here. And there's so much to talk about with this bill. It's a massive piece of legislation with so many different components in it. I suppose kind of picking up where We left off there. This isn't the first time that we've seen lawful access type provisions come up in Canada, I think 1999 is when we first start seeing these things surface. So it's been going around for a while, both in the legislature and in the courts. And I'm interested this time, perhaps if you could comment on what is the kind of the rhetorical justification for this, or the rationale. In other words, why these powers in this context now, from what you've been seeing?
So there has been almost no attempt, as far as I can discern from the press, the press statements and the public appearances by the minister tabling the bill to in some way justify why these new search powers have to be or should be or ought to be included in a bill about the border, about border enforcement. And so that raises the question, why now? Why here and why now? And one possible explanation is that behind the scenes, Canada has been negotiating an agreement under the U.S. Cloud Act. So the United States has legislation that permits the government to enter agreements with foreign governments about data sharing, to speed up data sharing when police have a warrant and so forth. So police think that somebody in Wyoming is engaging in activity using a website or a server in Norway, etc. We should have, it's very difficult to compel people in Norway to provide assistance, and so the United States has begun under the Cloud Act to negotiate treaties. It's done so with Australia and the United Kingdom to provide for more immediate access to law enforcement for data held in either country, and we're also in the process of negotiating. One possibility is that there's a whole bunch of commitments made during negotiations that we will quickly align our legislation with that of Australia, New Zealand, the UK, and provide domestic legislation that makes it easier for police to gain access if they have a warrant. And then maybe there are going to be new kinds of warrants, new kinds of orders in the Cloud Act treaty. So I think that's maybe one impetus for this. Another impetus has to do with what's been going on at the Supreme Court of Canada. So ever so briefly, and it's hard to avoid getting a bit technical here, but nevertheless, as Mike, you just mentioned a moment ago, that Canadian governments have wanted to pass lawful access legislation for a long time. They've gone every 2 or 3 years. It seems to get revived, but it's very controversial, and it is shelved. But what police want, they want a number of things, but one of the most common things they want is ready access. They want to be in a position to demand from people like Rogers and Shaw either an IP address or the subscriber information attaching to an IP address. It was assumed that a demand for those things engages Section 8 of the Charter, which guarantees a right to be secure against unreasonable search or seizure. But one question that was unclear was whether the demand for that information, whose account is this exactly? Can I have that information? Was that a search? Making that demand, was it a search? Something is only a search under the Charter if it interferes with a reasonable expectation of privacy over the thing or the place being searched. So back in 2004, in lockstep with countries around the world, we introduced what's called the production order. And it's a special warrant for information on probable grounds. And initially it was on reasonable suspicion. So police are using that or other kinds of warrants. And there's kind of confusion about is it even really necessary? And if so, is probable grounds enough? And so there's uncertainty in the law till 2014. And in that year, the Supreme Court of Canada, in a case called Spencer, said, yes, in that case, someone asked, if memory serves, Shaw, can we have the subscriber ID attaching to Mr. Spencer's, or rather to this IP address, which we think is Mr. Spencer? And they handed it over, and then Mr. Spencer said, well, wait a minute, that was a search. I have a privacy interest in the name attaching to my ISP account. And the Supreme Court of Canada said, yes, we agree, you have a privacy interest in subscriber ID, because once police have a name attaching to an account, an IP address, a search history, it can be quite revealing of very private information. So it's private, it engages Section 8. Police need authority and law to conduct a search. What the court did not say in Spencer was what kind of authority. So what do they need? Do they need a warrant on probable grounds? That was left unclear. Fast forward to 2024, and the court then asked the question, do you have a privacy interest in an IP address? And the court was divided in this case, 5-4. The majority said, yes, you do. But the dissent thought that that kind of information was a little too remote from truly private information. The police needed to take at least 2 or 3 further steps before it started to really interfere with really discover private information. So that engages Section 8, but there too the court didn't say what is required, and it's this uncertainty that Bill C-2 is taking advantage of, you could say. So I'll stop there.
Mm-hmm. No, that's a really helpful history of this as well, and I think the rationales have changed over time for the seeking of these powers, right? For major crimes investigations, often there's discussion of this being tied to investigations of child sex trafficking and sex crimes, and so usually a fairly serious argument made for the urgency and the need for these kinds of powers. It is interesting to me, and I'd love to hear your thoughts on how buried this content is in the broader border bill, which doesn't necessarily deal exclusively with borders, of course. C-2 has a whole bunch of stuff that deals with changes to the asylum system and immigration writ large. It's a very comprehensive bill, and as it often happens with these cases, because it's so massive, it's very difficult to get a mobilized critique in a coordinated fashion, right? There are different interests that are at stake here. So, what do you think about the inclusion of such extraordinary, serious changes in powers, especially the mobilization, I think, of internet service providers and other electronic service providers within this kind of broader bill?
Yeah, I haven't. I kind of looked at it to try to get a sense of what percentage of the bill, like the text of the bill. But my sense is that it's substantial. Like it's maybe something like 40% of the bill deals with these powers. And so one effect of their being buried in a sense, just like tucked in here, not taking up much of the spotlight when the bill is explained to the public, is that these are something that should be, these are so controversial, such a vast expansion of state power, so potentially disruptive or dangerous or negative to our privacy interests, that they ought to be debated on their own. That this should really be a standalone bill that is explained and justified on its own, and it just won't receive that. It won't receive that attention because other parts of the bill that are more politically salient, I think, are going to take the spotlight.
Could I ask a question it's a bit speculative, but I mean, we can definitely cut this question out, but I just can't help but think about how the timing of this kind of bill, which is, of course, immediately after the election of Donald Trump in the U.S., there's, of course, Trump, of course, taking a very belligerent kind of bullying stance towards Canada and other nations as well. There has been, I've noticed a trend, I think a lot of people who do, that when there are these sort of sense of national crises, whatever those crises are, states tend to push for more expansive powers in response to the crisis. And you mentioned that they had been wanting to do this. I should say they, but certain interests have been wanting to do this for some time. So how much of this is based in this sort of context of where we are right now in Canada in response to some of these perceived, whether real or not, crises?
It's a good question. I don't sense that 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 the that all these search powers that we're talking about are being included because of pressure from the United States. Although, as I mentioned, they may be in large part a response to commitments made under the negotiations for the cloud agreement.
Mm-hmm.
It may be the case that people at the Department of Justice took the view that it would be very advantageous for law enforcement in Canada for CSIS to have an agreement under the cloud agreement, and if one of the main conditions of that is for us to align with Australia and Britain and adopt all these powers, then we ought to move quickly in that regard. So in that sense, we are responding to pressure from the states, but it wouldn't be new pressure. I mean, the Cloud Act has been negotiated for some time. It predates Trump.
So let's. I mean, if we fast forward on this, and I know that there are a number of civil liberties organizations and groups in Canada who are opposing C-2 for a variety of reasons, or the Refugee Lawyers Association of Canada for some of the broader implications for immigration law, and many groups focusing on the lawful access and kind of lawful access analogous provisions here. But were this to pass, if we kind of look into the future here, I think maybe if you can give me a sense, in an everyday sense, of how this changes the expectations of privacy that people in Canada have. It is often a challenge when we're dealing with these kind of things to connect the dots between some of the more esoteric aspects of legislation and the lived experience of people on a day-to-day basis. So what does this change, or what would this change?
Well, I don't know that the changes to the production order power. So there's now going to be a new dedicated production order on reasonable suspicion. I don't know that that's going to change much, but there's going to be a new information demand power, a power for police to make an information demand of anyone providing an electronic service in Canada. So that could be anything from Google to, or it could be, like a website you don't want to be associated with. It could be Shaw and Rogers. And they're now in a position without a warrant, simply on reasonable suspicion, to ask for, to ask things like, does the person with this IP address or this phone number have an account with you? Where did you provide service? What services did you provide? Do you know of any other accounts or service providers with which they have accounts? And so there's like already a lot more information that can be gathered about your activity online without a warrant, and in a situation where the demand is made confidentially. So there's that. That may be more concerning, but much more concerning, I think, are the authorized access provisions. So it's now the case that I'm not a paranoid person, and I'm not suggesting we all now have cause to be paranoid, but it is a fact now that if this passes, whether your account or any person's account is subject to an order that provides for immediate access to your data, is just something you're not going to know. Mind you, that would be the case also with just an old-fashioned wiretap like that, whenever you use the phone and so on. So there's nothing new there. But there are differences. Like if you are subject to a wiretap, and you're not charged, there are provisions requiring that you be noticed, that you be notified, that you be told that, by the way, you were subject to a wiretap, that we were listening during this period, that sort of thing. We invaded your privacy. Even if we had authority to do so, that's not on the table here. I mean, that would be That would be if police had a wiretap warrant. But one concern is that the minister could make an order under the new bill that says you've got to modify your servers at Gmail or Instagram or whatever. You've got to modify them to allow this capability. And it may just happen that they're modified in such a way that allows for real-time access, even though they don't have an interception warrant. Now that's maybe, perhaps a bit fanciful, but how do we know? I mean, we just like there's no requirement in the new act that the minister report to Parliament about how it's using it. There's no requirement, as there is in the Australian bill, that the conduct of the minister, orders made, etc., be subject to independent review by, in Australia, the ombudsperson. So there isn't that equivalent here. I mean, they're just powers are given to the minister to act in secrecy, tell Google, tell whatever, tell Microsoft, Meta what to do, and no oversight. I mean, unless the only oversight would be if Meta goes to the federal court and says, this is a bit too onerous. We can't do this, this can't do this that quickly, etc. This is unreasonable. They can do that. But the only other form of oversight would be if John Smith is charged in a criminal case and his or her, or Jane Smith, if their defense counsel challenges the acquisition of data under Section 8 and does a bit of digging.
Yeah, and so and without being conspiratorial, as you say, I'm glad you raised this, because this is one of the things I was looking for when I was reading through the bill was some sense of monitoring, tracking, reporting. And instead, I think, as you pointed out at the outset, there's a lot of confidentiality built into the exercise of these powers. And even when there are, sometimes there's reasonable grounds for the use of extraordinary powers in a legal system. And I always like to see those powers exercised with a degree of transparency and with at least some capacity for oversight. And the scariest situations are where you have the combination of extraordinary powers and extraordinary secrecy, which leaves a lot of unknowns, and including unknowns about whether this kind of compromises general information security for systems, and about the relationship between these entities and the state. So, yeah. I think worth thinking about carefully. I know earlier iterations of lawful access had really focused on internet service providers in this kind of maybe a bit of a now kind of outdated model of telecommunications, whereas this now shifts the focus to something much broader, right? These kind of electronic service providers, and that's kind of a nebulous term to me. I mean, that can encompass a whole variety of different kinds of digital technologies and services. Is that kind of a broader, I guess, broadening of the scope of search powers to bring this concept in?
Yes. So it's just very broadly defined in the Act. So the Act applies to electronic service providers, who are defined as anyone who provides a service that involves the creation, storage, or transmission of data. So that could be really anything. That could be, a website.
Yeah.
So it's almost anybody, and it allows the minister to compel any electronic service provider to install equipment. In the case of any ESP, it would be temporary, but the minister can include any service provider on a list of core providers, who would then be making the modifications indefinitely. However, we haven't on the topic of vagueness, we haven't talked about the couple of important limits. And one worth mentioning is limits on the minister's powers. The Canadian bill adopts a feature of the Australian bill, and that is it has language to the effect that no provider needs to follow an order if doing so would introduce a systematic vulnerability. So that's the phrase. So that's good. That and just on a plain reading, you would assume that means they can't be compelled to build a backdoor to encryption. And however, the problem is that the phrase systematic vulnerability is defined in the Australian bill. It's defined as something like a change that would apply to the system as a whole rather than just to one user. The Canadian bill does something curious. It has a provision that says the minister can make regulations about the meaning of the terms encryption and systematic vulnerability. And so it's easily foreseeable that Canada can find itself in the position that the United Kingdom is in at the moment, where it's issued an order under their equivalent legislation, which does not have an explicit provision ruling out systematic vulnerabilities, where they're saying to Apple, this feature that you're using, that hinders access, remove it. And Apple is saying, no, but that would amount to a backdoor. So it could be the case that the minister says, well, I want you to do X, Y, and Z, and Apple comes back and says, no, but that would involve a systematic vulnerability. And the minister says, well, no, because we're defining it this way.
I can see the potential for some court cases arising from this down the road. I mean, I suppose if you have providers that have the pockets of Apple or Google, then that would be one thing. It'll be interesting if it's a smaller website or a smaller kind of business that's trying to negotiate what this kind of order means in that context. I noticed that this bill, there's a couple bills we're really tracking right now, and listeners to the podcast will hear us talk about C-4 as another kind of focus of legislation. These bills share in common that they touch on a number of different areas, let's say, of portfolios. But the way that the legislative process in Canada works is once it's gone through second reading and then it goes to committee for consideration. This one, C-2, is slated to go to the Committee on National Security and Public Safety, which to a certain degree makes sense, although, arguably all the asylum, all the immigration stuff in there, that's kind of interesting to come under the same umbrella as that. It's not going, though, to the Standing Committee on Ethics, Access to Information, and Privacy, where we would hope that there's more focused discussion of privacy implications of these things, and nor is C-4 going before that committee there. So it seems that these, one of the trends we're seeing is that bills that have privacy implications aren't really going before the bodies that have specific expertise in areas of privacy or even in search powers to deal with them, which is a curious development, I would say.
For sure. No, that's an astute observation, and it does. I think it will affect the quality of the debate around the bill, and who gets invited, what possible reforms or revisions are entertained. It's a huge concern. It's part and parcel. I mean, it just sort of suggests that the focus will be on concerns mainly about the border, features of the bill about the border.
Right.
Yeah. Although I hope that's not the case, but yeah, seems likely.
Robert, we wanted to make sure that people, of course, read your piece. We want to make sure that people know more about you as far as where people can read more about your work and learn more about what you do. Yeah, we'll be sure to link to that and your website and the piece.
Thanks for joining us, Robert.
Thank you for having me.
Access and Privacy Online reviews the headlines and delivers deeper commentary on a regular basis. Be sure to subscribe to get the full episodes every week and get notifications when we release show segments and other commentary throughout the week. We look forward to hearing from you soon. Have a good one.